Good afternoon, Mr. Kahl.
Good afternoon.
Please make yourself comfortable, and when you are ready, you may begin with your opening statement.
Thank you. Thank you, Ms. Roberts and members of the commission. I want to start by thanking all of you for taking the time and expending the effort to be part of this very important process for our state. I know I have the role of putting together 1/16 of the material that you all have to work your way through, and I respect very much the work that you have done. I thought I would start by talking a little bit about what I see as the role of the Court of Appeals, and then transition to how I would fit that service in that role. It seems to me our Court of Appeals has the obvious roles role to resolve disputes, but to do so in a manner which is respectful to the parties, is done in a cooperative and collegial way as a multi-judge court, is done with fidelity to the law and with a clear understanding of the facts and the record below. I think a part of that is also for a judge on the Court of Appeals to have the understanding that as a practical matter, with our Supreme Court taking such a small number of cases beyond the Court of Appeals, the Court of Appeals judgments are going to be the court of last resort for most litigants, and I think that that's something that the judge has to be very sensitive of. How would I accomplish that important work? Well, through diligence and hard work and application of the skills I've developed over the course of my career. I have almost 30 years as a trial and appellate advocate, and even 30 if you count the 2 years I served as a law clerk on a state court of appeals and a federal district court. My majority of my career has been as a public prosecutor. I think that is very important and a good fit for the Court of Appeals. Nearly half of the Court of Appeals docket is either criminal appeals or post-conviction relief matters, and that's been my bread and butter for the last 28 years. Moving to a judicial job would not be as huge a leap as one might think, in that as a public prosecutor, I already have a job that requires me to have perspective and exercise objectivity on the cases that come to the U.S. Attorney's Office. We have to make decisions as to whether charges should be filed, if charges should be filed, what those charges ought to be, what legal arguments to advance on behalf of the United States, what legal arguments to refrain from advancing on behalf of the United States, whether to pursue appeals. It's also a job that requires sensitivity to and awareness of the law's impact upon all of the folks affected by the criminal justice system and the judicial process. By that I mean witnesses, I mean crime victims, I mean law enforcement officers, I mean the community as a whole, and I mean certainly not to leave out people who may be on the receiving end of a charging decision. These groups of people are all very profoundly affected by the judicial process, and as a public prosecutor, I have to be conscious of the power that my position has and the very real impact it'll have on those people's lives. In terms of my own particular experience, I've had a diverse criminal caseload with a great depth of experience. I've handled everything from violent crimes to economic crimes to everything in between. I've used complex investigative tools, electronic surveillance, wiretaps, the federal grand jury. I've addressed complex legal and factual issues in my cases. All those experiences, I think, will be a tremendous value to the Court of Appeals. I'm used to working in a fast-paced environment, and I know the Court of Appeals has a heavy docket, a heavy caseload. I hope I come to this with a strong work ethic. I do want to pause and talk a moment about my appellate practice, because I have had a significant appellate practice. I've talked to many of you about that and tried to highlight that in my materials. Appellate work is different from trial work. And I know that from having done both. Appellate work requires you to look at a case in a unique way. It requires you to be stuck with the record that you have. You don't have you can't have the record you wish you have. You have what it is. You have to pay clear attention to the standards of review. You have to, at the same time, understand the realities and the practicalities of the trial court practice that preceded that. You have to be able to understand what matters are within the discretion of the trial judge, what matters are pure legal questions that get looked at anew by the appellate court. I want to talk a little bit more specifically about my work here in Iowa, my 22 years in federal court here in the Southern District of Iowa, based in Des Moines. As I indicated earlier, I have had a significant criminal practice and appellate practice there, all of which will be of a significant value to our Court of Appeals, I believe. I handle, because I am practicing in federal court in Iowa, I handle issues that routinely arise in both state and federal courts. Matters of federal constitutional law include matters relating to the right of counsel and effective assistance of counsel, search and seizure. Those are the same issues that arise in state court as well. I am familiar with areas of substantive Iowa law. The sex offender registry law has an analog on the federal side, and I actually argued the first federal sex offender registry case in the Eighth Circuit Court of Appeals when that was a new federal statute. State criminal statutes oftentimes become very relevant at federal sentencing when a defendant has prior criminal convictions under state law, and we spend a lot of time digging deeply into the state criminal statutes to determine what impact that's going to have on a federal sentence. We are bound, like everybody, by the Iowa Rules of Professional Responsibility. My one appearance in an Iowa court was in this courtroom in 2005 when the Iowa Supreme Court was considering the now established rules of professional responsibility that we all operate under when we were moving from the code, and I had the opportunity to represent my office in conveying certain concerns we had about the new rules and certain aspects that we wanted to have addressed. I finally want to talk a little bit about having had a unique opportunity to come to Iowa 22 years ago. I count myself extremely fortunate to live here, to have put down roots here, and to raise a family here. I count myself similarly fortunate to have practiced law in this state for the vast majority of my career, where we have both a historically collegial bench and bar. I point out I've lived here and worked here longer than anywhere else in my personal or professional life. I've handled cases affecting communities and individuals across the Southern District of Iowa, both in our urban centers and our rural communities. I look forward to continuing that service to the entire state as a judge on the Court of Appeals, and I look forward to your questions.
Thank you, Mr. Kahl. And so we do have some questions, and we will begin with Mr. Horbach.
Thank you, Madam Chair. As a layperson, could you just make a clarification for me? You're the appellate chief? Is that
I'm the
correct?
appellate chief for the U.S. Attorney's Office, which means that I review, I write some of them, but I review all of the appellate briefs that we file on the criminal side in the Eighth Circuit. That's about 100 briefs a year.
Yep, I read that. So my question is, for someone who doesn't know the court inside and out like me, especially at the federal level, is that process and knowledge and your experience very similar to what the state appellate courts are? I don't understand that.
I would say that there are many similarities. When I look at the cases coming down from the Iowa Supreme Court and the Iowa Court of Appeals, I oftentimes recognize fact patterns, recognize legal issues. We practice in a different venue, but it's the same sorts of issues, the same sorts of fact patterns. Of course, what I'm looking at on the federal side is narrower in that I'm a specialist on the criminal side, and our Court of Appeals also has other tasks and other kinds of cases that it looks at.
Thank you.
Mr. Bevel?
No questions.
Mrs. Sinclair?
No questions.
Ms. Valentine?
Thank you. I'm curious what prompted you to join the Iowa Bar by motion, being admitted on motion in 2015.
Sure. Initially, when I came to Iowa, I was practicing in federal court, and the rule was that you just had to be admitted to a state's high court bar, and I was admitted in New York because I'd gone to law school there and taken the New York bar exam, and sort of inertia kicks in, and there was no reason I thought for doing anything other than what I'd been doing. Eventually, it occurred to me that I'm not going anywhere, and it would be nice to be a little bit more involved in the state bar activities. I'd been involved in Blackstone and Newport and things of that nature, but to become more involved in the Iowa State Bar Association, for example, joining the bar was necessary to that, and also gives me the opportunity to appear before you here this afternoon.
Thank you.
Mr. Berger?
No questions.
Ms. Stanger?
Yes, thank you. Can you share with the commission your perspective, having traveled the Southern District of Iowa? You had identified rural and urban communities. I'd like to hear your thoughts as to whether those sorts of differences from the different communities and geographic diversity matters for this commission's consideration of the applicants. And if so, why? Isn't the state of Iowa, isn't the law the same across the state?
The law certainly is going to be the same across the state. I think there are differences in the way things bubble up and the way disputes happen, the way people respond to crimes. I was thinking about that coming down this morning about some bank robbery cases that I'd done. I included the Ross case as an example in my materials. That was a defendant who victimized small banks in rural Iowa. He was aimed towards finding banks near the county line so they would be far away from the county seat. He looked to rob banks on snowy days to delay the response time. And those victims felt very, very, very vulnerable in a different way than similar bank robberies I've prosecuted here in the Des Moines metro, where the response time is very quick. So the circumstances of the offense seem a little bit different, but the ultimate law that is being applied is the same. And both of those defendants in the cases I'm thinking about are serving essentially life sentences because of the nature of the offense, and in one case because of the nature of the criminal history.
Thank you.
Ms. Pearson?
No question.
Mr. Gray?
Sir, many of the applicants have been asked today whether they think having experience as a district court judge is important. What would you say to that?
Well, you can put me in the no column.
Okay. And why not?
The two things I would say is an advantage I have over a district court judge is while I do have significant trial experience, I also have that significant appellate experience. And as I talked about in my opening remarks, appellate work is different than trial work. It's a different way of thinking about cases. It's a different way of thinking about the record. It's a collegial process on a multi-member court. Certainly, having sat as a district judge does bring some experience of that is of some value, but I don't think that it should be the be-all and end-all. If that were the case, we would have a very different look of our current Court of Appeals, or our current Supreme Court, or our current Eighth Circuit Court of Appeals. There are many judges who came to those courts directly from private practice or government service. I think you have an opportunity to provide the governor a mix of candidates, and that's just one factor.
Thank you, sir.
Ms. Law?
No questions, thank you.
Mr. Goodman?
No questions.
Mr. Sukup?
Thank you, Mr. Kahl. Outside the courtroom, what would you say is your most rewarding service?
I would say probably the things having to do with my kids at this juncture, whether it's going on Boy Scout campouts or being a chaperone for the high school speech and debate tournaments is where I get my greatest opportunity to be active in the community.
Thank you.
Ms. O'Brien?
No questions, thank you.
Mr. Hoytick?
I had the pleasure of clerking for a judge who sat on the federal district court and then sat on the Federal Circuit Court of Appeals. And he was quite open, and I think has been open to pretty much anyone, that the jobs are very different, being an appellate court judge versus being a district court judge. You've had significant trial experience and significant appellate court experience. What do you think makes the difference between the two types of judges? What are the qualities that distinguishes a great appellate court judge from a great district court judge?
I think some of the fundamental qualities are going to be the same. A respect for the litigants and understanding that the parties need to be heard and understood, and understanding that the non-prevailing party still needs to come away from the proceeding with an idea that that party was treated fairly. It's really, the difference is more in the kind of work the appellate judge has the luxury of a little bit more study time and an opportunity to work in that collegial atmosphere with other judges, whereas the trial judge has to do it all on his or her own.
Thank you.
Mr. Spies?
Thank you. Hi, Mr. Kahl.
Good
You and I
afternoon.
have argued in front of the Eighth Circuit, and I know that in advance of oral argument, you scope out who's on your panel and try to discern, I was going to say their peculiarities, I mean their unique perspectives. And based on your experience before the Eighth Circuit or before any court, is there a judge or a justice whose approach to appellate review you would most like to emulate?
I think I would name the late Richard Arnold on the Eighth Circuit as a judge fitting that mold. He was invariably courteous. He was invariably extraordinarily well prepared. He always wanted to do the right thing and did accomplish that. He was an incredibly bright guy and extraordinarily collegial.
Thanks.
Mr. Bloom?
Well, I know it's a little different since you're a federal employee, but what are you most proud of in terms of your contributions to the profession in the capacity you're in?
My contributions to the profession, I would think my work on the Federal Practice Committee with the State Bar Association has been very rewarding. We put on an annual CLE, which is always very well received every year for the federal practitioners. That's a tangible result. What I think I am also most proud of is performing my work, I hope, in a manner of integrity and fair play, and that hopefully is a legacy that I will leave behind at some point.
Certainly your testimonial letters reflect that too. So.
Thank you.
Well, Mr. Kahl, we've come to the end of our time today, and I again slight you, Ms. Conover. But thank you for being here, and we wish you well.
Thank you very much.
Thank you.